literally what I'm working towards. So like, I
God,
decided
not being a
started.
lawyer, I hope.
Yes. Don't say
Ah.
it like, oh, don't say it like that. Why'd you say
Oh
why
man.
like that? Like, oh my goodness.
Well, it depends. What kind of law are you looking at?
Consumer
Like,
law, specifically.
oh yeah, we could totally use you. Yeah, please come
Like
in,
I
come
was
in as quick as you can. Oh, your audio just disappeared. I can't hear you. No, stop talking. I can't hear you. You died on me there, Markia. You're muted.
Can you hear me now?
Ah, you were muted.
I was like, what in the world? So I was like, yeah, like I want to be a consumer lawyer. Like that is my goal right now. Like I'm going back to school in the fall. I
Mm-hmm.
don't know why I wait till I'm this old to go back to school, but I'm going back to school in the fall. And like I'm obsessed with that side of the financial literacy world. Like I really feel like that's kind of what's given me my advantage as a credit repair specialist is kind of like because I know and study the laws so much. Like, what
It
do you think is the hardest part about being a consumer lawyer?
it's frustration. Um, First of all, when I said hurry up and get in because we could use you, I'm not kidding. The consumer law bar is incredibly old. I mean, I'm 52 and I'm still one of the younger people in the field. Like we are we are like Q-tip central. It's really old.
Mm.
And a lot of the really good attorneys are getting to the point where they're just retiring. Um, and so there's that problem. There's not a whole lot of people who are doing the work and doing it really well, and who actually care. The second thing that's really troubling is, from a litigation standpoint, judges tend to look at consumers in and this depends court to court, but in a lot of courts, judges will look at consumers in the same way that a debt collector will look at somebody who owes a past due debt. Like the FDCPA, it doesn't matter if you owe the debt because that's not what it controls. It controls the playing field. It controls the way the collections can go forward. So when you bring a case under the FDCPA or in California the Rosenthal Act or any of the state what are called UDAP laws, unfair and deceptive acts and practices, a lot of judges will start the show by saying, "Well, do they owe the debt? And if they owe the debt, why don't they just pay it?" And so that becomes problematic. Um, and as far as people who are being sued for past due debts, over 95% of those consumers do not take any action, and the lawsuit just goes to a default judgment, and that's just game over. So outreach is really important. And so people like you who've got an ability and a willingness to go out and talk to the public about these things, I don't think you realize just how rare it really is. Um, I'm one of how many consumer attorneys on TikTok?
You're
Like,
literally the only one I know.
I there's 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 a couple of labor lawyers, one or two class action attorneys, but yeah, there's not that many of us. So you don't realize just how rare it is. So the quicker you get in, the happier I'm going to be.
I'm so like it's like I said, I'm fangirling over you a little bit because like looking at your content and it's like man and because you have the action behind the words, like I can say all of these things, but you have the actual experience to be like, look, this is what's going to happen when you go to court. Like I can only tell them what has the potential to happen, but you've literally lived it. Someone on YouTube
Thank you.
asked, how can they find a consumer lawyer if they're looking? They're currently in the state of Georgia and it's due to bankruptcy.
Sure. So for bankruptcy attorneys, my go-to place is the National Association of Consumer Bankruptcy Attorneys. It's the largest nationwide group of attorneys. It's the American Bar Association for consumer bankruptcy attorneys. They only represent people who need to file for bankruptcy. So you don't have to worry that you're going to try to connect to somebody and it's going to be like a Citibank lawyer or a
Mm.
Midland funding lawyer. It's all people who operate on the consumer side. I'm a member of NACPA. I've been a member of NACPA since 2002. I can't speak highly enough about the group. If you're looking for somebody and you can't find anybody or it gets too confusing, just drop me a DM. I've been in the field for 26 years. I know people in a lot of places, so I'm happy to shuttle you to somebody. As far as other consumer work, your repo problems, your lemon law, your debt collection, your credit reporting, your spam phone calls and text messages. There you can go to the National Association of Consumer Advocates. You can just type that into Google, and their website used to be NACA.net, and I consistently forget it. I think it's consumeradvocates.org now. And they've got a find an attorney tab as well.
So for
So
some
those go ahead.
for someone, let's say this person is saying they have a bankruptcy that's for some reason reporting, but they've never filed bankruptcy. So let's say that they've tried to remove it. Nobody wants to get rid of it. What kind of lawyer would they need for that?
Oh, then you're not going to want a bankruptcy lawyer. You're going to want a credit reporting attorney. So you're going to want somebody through the National Association of Consumer Advocates. It sounds like if this person has never filed for bankruptcy, yet bankruptcy is showing up on their credit report, and they've gone through dispute processes and it hasn't worked out, it's what we call a mixed merge file. I don't even know if that's a technical term.
That's how I learned it. So I'm assuming it is.
Okay. Either that or we both learned in the same place,
That's what
one
I
way
was
or the other.
thinking. Like, whew.
Yeah, but that's a mixed merge file, and you're going to want a consumer attorney who handles credit reporting litigation, FCRA. And those lawyers, and Markia, I know you and I went back and forth about this. Consumer attorneys, for the most part, are going to operate on a contingency basis. At the very worst, they may require that you pay court costs, the filing fee to file a summons and complaint, just so that you've got a little bit of skin in the game. But that's just a couple of $100. I don't want to say just a couple of $100 because money's money, but you're not going to be going out of pocket for hundreds of dollars and hours for an attorney. Many of these statutes provide either what's called fee shifting. In other words, loser pays the attorney's fees, or if not, then your attorney will work something out as a percentage of your financial recovery. So makes it easier. And a lot of people don't realize that.
So I didn't even realize there was that many different types of lawyers. I thought a consumer lawyer was just a consumer lawyer. So bankruptcy lawyers aren't the same people that'll go to court if you're being sued by a debt collector.
Right. For the most part, and like I said, I've been a bankruptcy attorney for a little over 26 years. I opened my practice December 19th, 1995. I am ancient. So, and most bankruptcy attorneys only do bankruptcy work. That's it. They go into bankruptcy court. That's it. And if you don't need to be in bankruptcy court, they're going to either send you away, or there may be somebody who's going to try to fit a round peg into a square hole. Not many people do that, but I'm just saying buyer beware. Bankruptcy is incredibly specialized, and it's kind of like a general practitioner versus a neurosurgeon. Not saying bankruptcy is neurosurgery, but it's incredibly specialized. And then, so you've got bankruptcy over here. Then you've got your world of consumer law, which is also handled really specifically. For example, I don't do lemon law cases. You buy a car, you drive it off the lot and it blows up. I'm not the guy to help you. I don't know anything about that. There are people who do only lemon law work. There are people who only do debt collection, FDCPA work. Some only do FCRA work. Some do defensive lawsuits in civil court. I'm one of the few who kind of does all of it.
Mhm.
Again, not everything, because say I don't do lemon law work, but I do so much of it because I'm ridiculously curious and I hate not knowing the answer to something, which is kind of how I back myself into so many of the things that I've done over the years.
I honestly feel like that's how I got into this. Like somebody was like, "Oh, you should post that." Oh, okay, and then it's kind of like blown up into this because I just can't say no. But so for those, we've been talking for a while now.
Yeah.
So for those who are not familiar with you, introduce yourself.
Okay, sure. My name is Jay Fleischman. I am MoneyWise lawyer on TikTok, on Twitter, on Facebook. My page is MoneyWise lawyer. I practice originally in New York. I was admitted to practice in the beginning of 1995. I worked for a firm for a very short period of time because I like to think that I'm a better lawyer than an employee. Um, I'm an only child, so that's kind of how we roll. Yeah. And I have one child, so I've decided to pass that along to the next generation.
If you could pass anything down.
Yeah, there you go. And then it was 2011, I decided that because taking the bar is so much fun, it's not. I decided that I was going to take the California bar, moved from New York to California. Now I practice in both states, handling state and federal practice. And then for student loan work, which really does comprise, at this point, I would say 97% of all of my work. I handle federal student loan resolution nationwide. And then student loan litigation, again, only in New York and California. And that's it.
When would someone need a lawyer for their student loans?
Ideally, you would never need a lawyer for your student loans. That would be great. Um, I, you know, I've told people for 26 years, I would love nothing more than to be rendered completely obsolete. It would make me so happy. If nobody ever needed me for bankruptcy or credit problems or student loan work, I'd be thrilled. I could figure something else out to do, I'm sure. Um, so, but going back, when would somebody need an attorney for student loans? When you come, ideally, when you come into repayment the first time.
Okay.
You don't need the lawyer then. Ideally, when you come into repayment the first time, you can sit down and get a real sense of what your repayment obligations are going to be, what your repayment options are going to be, and how to maximize your benefits under those systems. If you can do that, you don't need a lawyer, and you should just revisit it every once in a while. It's not one of those set it and forget it sort of things. However, most people don't really understand what their payment obligations are and how to manage those payments. And so they fall behind, or they see that their balance has gone through the roof, or they wake up one day and they're in default, or there's a wage garnishment, or they're getting a call from a debt collector. And that's really the time that most people are going to come in and find me. Now that we've been in this COVID forbearance for so long, people are coming to me as we come closer and closer to the end of it, or what may very well be the end of it. Nobody even knows anymore. And they're coming to seek me out to say, okay, look, here's what my loans have been like up until now. Now that this forbearance is ending and we've had some time to catch our breath, hopefully, what do I do now? And so that's when a lot of people are getting in touch with me at this point. Plus all of these new programs and expansions and waivers and a million headlines creates an enormous amount of confusion in the marketplace. So
I'm going
that's
to
it.
ask you this, and I know you get this question a lot. Is Joe Biden going to forgive all the student loans?
All of them? No. If he does, I would look outside to see if it's raining frogs. because I just don't see that happening. I mean,
Why
look,
not? Like it sounds like such a good idea. Yeah, I mean,
I think it's a great idea. And first, let me start from here because I'm going to say some stuff about Joe Biden, and I don't want my political leanings to be misconstrued. I voted for him. If he runs again, I'm going to vote for him again, and that's just the way that it's going to be. And in spite of the fact that he is not going to do what I want him to do for student loan borrowers, for people in debt, for a whole host of consumer options, I'm still going to vote for him if he runs because he's, in my mind, politically, socially, etc. He's better than the other side. So I I just got to say that at the outset. Joe Biden is a 1985 Republican. That's who he is. He's an old guy who grew up in a world of centrist politics, and he is far closer economically to, say, Ronald Reagan or probably a lot closer to Bill Clinton, who is
mhm.
much more fiscally conservative than he is to the left or to the further left side of the Democratic Party. Um, he was a senator from Delaware. They used to call him the senator from MBNA. And for people who don't remember MBNA, they became FIA Card Services, and now they're part of Bank of America. He's a banking dude. He's a money guy. He's not going to screw over the people who have the money. It's
Because that's
just the
his
way that it
background.
is. Um, he's not going to get rid of all of them.
That
Um,
makes sense.
and whether you think that that's right or not, I think that it would be great if he got rid of all of them. I don't know how old anybody else's kids are. My kid's in high school. He's going to be going to college at some point.
Mm.
Unless there's something in place that prevents this from happening again, I think that he's got an uphill battle on just the whole idea of getting rid of student debt.
So when it comes to like student loan like consolidation or settlement, what is
Mhm.
one of the biggest mistakes that you think people make when kind of entering that process?
Pennies on the dollar. You've heard that term, right?
Oh my God, yes. I hate it so bad. Like, oh,
Oh, kills me. So pennies on the dollar may work more for credit cards and personal loans and even private student loans. And we can definitely talk about that. But federal student loans are settled as the result of regulation, not as the result of negotiation. So it's not, well, I'm going to go into default, wait until I go into collections, and then I'm going to try to get a deal. There's no deal. That's not the way that it works. You get certain levels of settlement only on approval. Debt collectors do not just settle out of hand. And when they do settle, you're looking at a lump sum payment of a large percentage of what you owe, and you're looking at cash at the door. So this isn't like, oh, I'll pay you 25 cents on the dollar and I'll pay you over the next 5 years. For a federal student loan, you're probably headed towards about 90% of the principal and interest balance. And you're looking at payment of that money within a very short period of time of making that deal. And
okay.
honestly, if you had all that money to make that deal,
You'd have paid it
probably
initially.
you probably would have paid it.
So with student loans, do you feel as though well, I mean, I kind of know what the answer to this already. When is it better to be proactive, like kind of seeking out the help before it's necessarily needed, like when we think that could be an option, or is it best to wait to be like, you know what? No, maybe I got this, maybe I got this, maybe I got this, or shit, I don't have it.
Yeah, you don't want to wait that long because once you fall off the cliff into default, things get a whole lot more difficult. At 270 days past due on your federal student loans, you go into default.
Mm.
That means the entire balance is due. collection costs of 25% of the principal and interest balance get tacked on top of it. Interest continues to accrue, so those collection costs continue to go up. Your opportunity for getting out of default can get smaller and smaller as time goes on, depending upon what the government does in terms of enforcement. And in terms of enforcement, the government can start a wage garnishment without filing a lawsuit against you.
Wait,
And
what? Wait.
yeah,
What?
administrative wage garnishment. It's the same process as if you've got past due taxes and you don't do anything about it, or if you've got an overpayment on, say, Social Security or other federal benefit. It's an administrative wage garnishment. They send you a letter, which if you don't get, that's not their fault and that's not their problem. They send you a letter. They give you 30 days to request a hearing. If you don't respond and request a hearing within 30 days, they can just start an administrative wage garnishment, 25% of your disposable income.
Oh my God. Oh my God.
Yeah. And so they can do the administrative wage garnishment. They can take your federal income tax refunds. And so if you're married and you file a joint federal income tax return, your spouse's refund is going to get taken too, and then they can get it back by jumping through hoops with the IRS, but it's painful and long and it's money out of their pocket. They can take part of your, not only your Social Security, which is what everybody knows about, they can take part of your federal benefits, whatever form of federal benefits you're getting. They can offset a portion of your federal benefits. If it is Social Security, they can take a big chunk of it and leave you with, I think it's like $750 a month. So if you're living on Social Security,
what about like VA disability, retiree pay, that sort of thing as well?
Retiree pay, VA disability, it depends upon how that VA disability was done. But if you've got VA disability and it's 100% disability based upon a service-related injury, you can get your federal student loans just wiped out.
Yeah. Okay, so the lawsuit part, because before we go past that, because I do got a question about that.
Sure.
So I know I just taught a class recently about the SCRA. Does that apply when it comes to how these are handled? Because I know with the SCRA, before you can take like legal action, you have to go to court. But you're saying that they can bypass that part. How does that work for someone protected under that?
Sure. So going to court and a judgment is only the result of a court process. So you file a summons and complaint, it gets served on you, you have 30 days to file a response. If you don't file a response, they can get a default judgment against you. And then they can utilize enforcement mechanisms that are provided for by law for judgments. Then it becomes judgment enforcement. Anything else is purely administrative. Take your tax refund, all they got to do is send you a letter. They refer you to Treasury Offset, TOP. They're going to take your, they're going to do an administrative wage garnishment. All they do is they have to send you a letter and give you 30 days to request a hearing. None of that goes through the court system.
Someone is saying that, this is a good question. Can your student loans be included in your bankruptcy?
Include? Yes. So here's why I hooked on your word include. Include, to me, the bankruptcy lawyer says, do I list it as one of my debts on my bankruptcy papers? And the answer to that is yes. Every debt has to be listed, no matter who you owe the money to, small, big. I owe my brother $50 by law. I have to put him down as a creditor, stuff like that. Everything. So included, yes. Inclusion does not translate to discharge. And that's the real question. I'm sorry, I'm being a pain.
No, but that's important to note, because some people might think just because they included it, it would be offset because of the bankruptcy.
Yep. And that's exactly why I said it. There are so many people who will get in touch with me and say, hey, this was included in my bankruptcy. I'm like, nah, it wasn't. It was listed on your bankruptcy. Totally different animal. In order to get your student loans discharged, wiped out in your bankruptcy, you need to file well, first of all, you have to make sure that it's a student loan as far as the bankruptcy code is concerned. Not every student loan is a student loan for bankruptcy purposes. I'll get to that in a minute. Um, presuming that it is a student loan, however, what you need to do is you need to file a separate lawsuit in bankruptcy court. The technical term is an adversary proceeding. It's a separate lawsuit filed by you, the debtor. That's the term in bankruptcy. The debtor files the adversary proceeding against the lender, the holder of the loan, all those folks. And the goal of that lawsuit is for a determination by the judge that the student loan constitutes an undue hardship. If you win, the loan gets wiped out. If you don't win, the loan doesn't get wiped out. The problem is, first of all, undue hardship. I don't know. Have you ever seen the movie The Princess Bride?
Yes. Yes.
Okay. Undue hardship. That word, it doesn't mean what you think it means.
Yeah.
Undue hardship doesn't mean, oh, this stinks. It's really tough to pay my student loan. Undue hardship means different things depending upon where you are. It means different things based upon what bankruptcy court your case has been filed in. Most of the country relies on a 3-part test that came out of New York by somebody who, as far as I was concerned, never should have brought the case in the first place. It's called the Brunner test. And the 3-part test looks backwards to how you've handled the student loan up until now and your financial situation. It's called the good faith test. Have you done everything you can to minimize your expenses and maximize your income? Have you worked with the student loan folks in good faith? That's the backwards looking test. The current test, the present moment test, is whether your current income and expenses allow you to live a minimal standard of living and provide for yourself and your dependents and still pay the student loans. And then, and those two tests, they're pretty straightforward. I mean, there are some minor changes, but court to court, they're pretty standard ways of applying them. The third part is really the hard part. That's the forward-looking one. And that third part test is whether it is reasonable to presume, based upon factors outside of your control, that your current financial situation is likely to persist for the remainder of the student loan repayment period. That's the hard part. A lot of courts have looked at that and said, well, that means you've got to be disabled. That means that your dependents got to be disabled. That means that you've got skills that don't translate into the current workforce. You make buggy whips and there's no call for buggy whips anymore. And you've got no other way to make a living.
Now, does this apply for both federal and private, or is this still strictly federal?
So in bankruptcy, like, are you feeding, like, have you read all of, like, I just want to let everybody know, we didn't rehearse this before. We don't have like a list of questions off screen that we're feeding. But and I say it because this is the thing that people ask. In bankruptcy, there's no distinction necessarily between federal and private student loans. It's either a student loan or it isn't. Let me explain. Federal student loans in bankruptcy are any loans that are underwritten by or guaranteed in part or in whole by any government. I didn't say federal government, by the way. Could be state government. There's even a bankruptcy case that talks about a foreign government. Like, there was a Canadian student loan. Somebody filed for bankruptcy in California, tried to wipe it out, saying, well, it was Canadian, so it's not one of our government entities. And the court's like, yeah, no, it's still a government. So take a hike. So any government entity or any nonprofit, any not-for-profit entity. And that's where a lot of student loans, It used to be. It used to be that it was federal student loans were non-dischargeable unless you filed an adversary proceeding.
Mhm.
Private loans were considered separate, but there was still that hook for the not-for-profit. And so companies like Sallie Mae or any of the lenders that were involved in called National Collegiate Student Loan Trust, which was like a behemoth in private student lending because they were behind all of the private banks that were doing their own student loan products like Chase and Bank One and Wells Fargo and back when in Washington Mutual, Bank of America, all those folks. Um, all of those companies set themselves up with not-for-profit guarantee agencies sitting behind them. So like Sallie Mae had one. So even though it was a private student loan, there was this not-for-profit behind it, which would make the loan not automatically discharged in bankruptcy. The change in the bankruptcy laws that expanded it to private student loans didn't really do anything except save the private student loan lenders money because they no longer needed to deal with these not-for-profit guarantees that were shaving off their profits. Like that's all it was. It was just a money grab. So fun stuff from big bucks. Um, so you have those student loans are not automatically discharged. And then any other loan given for a higher education purpose, not necessarily used for higher education, but a higher education purpose. And the way that you make that determination is largely by looking at the IRS regulations in the Internal Revenue Code. It's Section 221. Talks about what is considered an educational expense and an educational debt for the purposes of being able to deduct a portion of the interest on your taxes. So that's where a lot of those private student loans come in.
That's crazy how it kind of goes that deep into it. Like I thought it was literally just who gave you the loan and it was just kind of like that simple.
Yeah, it's crazy. Sallie Mae, for a large period of time, actually, a lot of the Sallie Mae private student loans did not have a private guarantee behind them. They just didn't. They were done through separate channels, through banks that Sallie Mae had gobbled up over a period of time. And so a lot of those loans, you'll walk into bankruptcy court, you'll think that it's a student loan, and then you do just a little bit of digging, you're like, oh, wait a minute, this isn't a student loan for the purposes of bankruptcy.
Because it
So
didn't have that like that backing. Oh my
yep,
goodness.
it didn't check all of the boxes. On the flip side, legally, and I'm not saying that I've ever seen this happen. I'm not saying that anybody else has ever seen this happen. If you have a student loan that you were to pay off, say, using a credit card or a private debt that isn't like a refinance, technically by law, that debt is still considered a student loan, even though it's on your credit card.
Wait, how? What?
Any loan used to refinance a student loan is still considered a student loan if the original loan qualified as a student loan under the bankruptcy code. You
Wow.
sure you want to be a lawyer? This is crazy
I'm
stuff.
learning, and but you know what's so crazy? Instead of like making me not want, this is like it just intriguing me so much more. Like, oh my god, like I'm literally like loving this right now.
It
So,
is, it's fascinating. It is.
so when it comes to, so somebody said that they're getting their social security garnished because of their student loans.
Mhm.
Now, it are there ways to kind of come back to the table if like I feel like they're taking way too much money, I want to try to settle this. Like what is that process if you are already under a wage garnishment? What can you do to try to kind of go back to the negotiation table and settle the debt?
Better than settling the debt. First, let me just be upfront. I think that debt settlement for federal student loans is, even if you have the money, I think it's a terrible idea because you've got other options available. So talk about those other options. To get out of default on your federal student loan, you've got two ways. Forget about settlement, forget about paying in full. Let's put those to the side. You've got generally two ways. One of them is rehabilitation, and the other one is consolidation. Rehabilitation involves entering into an agreement with the debt collector handling the account to make a series of payments, 9 monthly payments of an agreed upon amount over a 10-month period of time. At the end of that payment cycle, your loan is taken out of default and put into good standing. The minute it's out of default, that garnishee comes off of your, if it's an administrative wage garnishment or the offset on your Social Security, stuff like that. That all stops as soon as the loan comes back into good standing. There's some requirements for it, but your rehabilitation payment can be as low as $5 a month.
Wow. What? Wait. So what you're pretty much so pretty much what you're saying is like, even if you've entered the garnishment stage, right? If you go back and try to rehab your loan, you could actually come out better than what you were in the first place.
Well,
I mean, you still
better,
have to pay, but it's better than damn garnishment, right? Like,
yeah, exactly.
And it's crazy because most people, like, especially in my industry, they're like, "Oh, take the student loans off. Take them off. You don't need them on your credit report. Take them off." But it actually makes better sense for you to try to rehab it because then you're not hiding it for the rest of your life.
You want to have more fun? If you rehab, once you complete the rehab agreement, the default comes off of your credit report.
So, like, what about the late payments and all that stuff that's gone?
The past due stuff remains.
Okay.
But the default comes off, and you know that's
blemish on your credit report. Yeah.
Yep, exactly. And then you're in repayment. Once you come out of default, like the reason why a lot of people don't want to come out of default is because there's that looming, well, I'm out of default. And now what do I do? Now I've got this, $150,000 in federal student loan debt. I still can't pay it. So I'm just going to be right back where I am. I don't want to put myself into that bad situation, especially if the loan's been in default for so long that it's off my credit report. Right?
Wow, that is ridiculous.
Mm-hmm.
Oh my God.
Mm-hmm.
Somebody said,
God.
What? Oh, I misread the comment. It threw me off a little bit.
Okay.
Did you guys already go over what they need to prove in order for us to move forward with a wage garnishment?
What they need to, they don't need to prove anything.
Wow.
Here's the thing about the federal government. When it comes to federal student loans, you lose, they win. This whole show me the note and I want to know that the amounts are correct, and it's not going to take anywhere. It isn't. You get a notice that there's a pending wage garnishment. You get 30 days to request a hearing. Yeah, there are grounds for the hearing. I paid it in full, so I don't owe the money. Well, guess what? Now you need to show us that you paid it in full. Our system is set up as innocent until proven guilty, and this isn't a criminal case. But you got to think of it as this is kind of things on its head. You lose until and unless you prove that you have a reason to win. So I paid it in full. Great. Show us proof that you paid it in full. Well, it was 15 years ago. I don't have copies of my checks. Guess what? You lose. Mm-hmm. I never took out the loan. Well, if you didn't take out the loan, here's a copy of the promissory note. Oh, it's only a copy and it's electronic. Well, too bad. This is the way that we have it. Do you have any proof that it wasn't you? Well, I didn't sign it. Did you go to this school? Yeah. Did you go these years? Yeah. Here's your transcript. Okay. Guess what? You lose over and over and over again. You get boxed out in so many ways. Not saying don't request a hearing, but this isn't a place to play fast and loose. It just isn't. So
do they offer like mediation when it comes to student loans, or is it just like straight to court?
Remember, this has nothing to do with court. This is all an administrative process.
Right. You said they don't have to go to, oh my God. Yep. Oh my God. Now I got heart palpitations for everybody and I don't even have student loans. I don't even have student loans. But this is so scary because it's
It
crazy
is.
because these are the ramifications for a decision that most people make at 17 and 3/4 or 18. When
Yep.
you sign up for student loans, all you're thinking is, I want to go to college and be somebody. You never think that 4 or 5 years into the future, you're not going to have the money to pay for these things. And so to see such a harsh consequence for a decision we made as children, like this is just mind blowing.
Oh yeah. Yeah. And
Somebody said, oh, go ahead, go ahead.
no, please, go ahead.
It was just another question. I wanted
Go
you
ahead.
to finish first. Oh, so somebody said, I consolidated 4 defaulted student loans. Will the old negative history still report on my credit report?
Yes. The consolidation will result in the old defaulted loan being paid off. So it'll say was in default, now zero balance due. It'll report for the same term. The only way to get that default off is through rehabilitation. But in a lot of ways, this is 6 of one, half dozen of the other. Remember, rehab's going to take you 9 monthly payments over a 10-month period of time. It's going to take a little bit of time for the loan to get reassigned. So you're probably looking at near on a year before that default comes off and you start reporting positively. And during that time, you're still in default. So during that time, you're still, if your tax refund's being taken, it's still going to be taken. And this is a big thing, federal student loan in default means you're not getting an FHA mortgage because you're reported on CAVers. And that's
Yep.
a lot of people come to me. They're like, oh no, I didn't even know about this. And now I'm sitting here and we're going to closing in, 30 days. What do I do? Should I rehab? I'm like, no, it's going to
Too
take
late.
too long. If you've got a need for speed, consolidation is your way to go.
Wow. And it's so funny because I literally just learned about like what CAVers is. Shout out to Rebecca because she told me.
Yeah.
But and so like, there's so many people who come to people like me, credit repair specialists, and they're like, listen, I don't care what the cost, like what it costs. I have to get these student loans off so that I can get a house. Then I find out that, oh, they're still going to be able to see that on CAVers. You know that, right? Like,
Yeah.
so then it's just like, you did all that for nothing.
Yeah, it's crazy. It is. But,
So, this is a really good one.
Go ahead.
How do I remove a cosigner from a vehicle loan? The person that needs to be removed is in prison, serving a life sentence. And according to the tax office and dealerships, the vehicle cannot be sold or traded without their signature. I see this all the time with people who are divorced.
Oh, yeah. Divorce is the worst thing. I gotta talk about one thing about divorce. Divorce is a terrible thing just in general, just because whether you want it or not, it's still like a thing. A lot of people have joint credit cards, not authorized user, but a joint credit card. And then they go through divorce. They come to an agreement with their soon to be former spouse that other person is going to pay the credit card debt off. Then, of course, they don't pay the credit card debt off. And they're like, well, no, it's theirs. They said that they would pay it. That agreement between you and your former spouse is not binding on the creditor because the creditor wasn't a party to that agreement. So it doesn't matter who agreed to what. If, Citibank or Amex or Discover weren't sitting at the table and sign off on it also, it means absolutely nothing.
Wow.
So that's it.
And let me tell you, as somebody who has been divorced, and it's so funny that you said that song, Alec, because like I was divorced. My ex went to jail. And so all of the debt that we had as a couple fell on me. And at first I was like, well, I'm not going to pay it because that's what we agreed they would pay it. Nobody wants to hear that. All they want to know is who's going to sign the check.
Yep. Yeah. It's crazy. On this car that the question came in, is it that the car loan is held jointly, or is it that the title is held jointly? If there are two names on title or registration, that's a total different ball of wax. You got to go through your state's DMV. to see if there is a solution to it. There may not be.
Mm.
You may have to get your name on the
I think they're on
list
the
and
title. Yeah, he said the
okay.
title. He said the car is paid off, but he has to sign so we can trade it in, unfortunately. Thanks for the info. Wow.
Yeah.
That is
Well,
so crazy.
yeah. So there's
Yeah, it's North
that.
Carolina. Of course it is. Of course it is.
North Carolina, though, interesting. North Carolina has some of the strongest state laws that protect consumers against debt collectors.
Really?
The North Carolina UDAP laws, unfair and deceptive acts and practices laws,
I need to
are incredibly strong, incredibly good. They allow for, say, it's called stacking of damages. If you file a lawsuit under the Fair Debt Collection Practices Act, you're out of the gate. Your out of the gate damages are $1,000. So
Mhm.
even if it didn't particularly bother you that they broke the law, but they did anyway, you suffered no harm, you get $1,000. It doesn't matter how many times the debt collector violates the law, you get $1,000. North Carolina, and I've got friends of mine who practice there. In North Carolina, it allows for stacking of damages. So
Mm.
if the debt collector sends you one letter that violates, but they send it 10 times, it's not just $1,000.
Mm.
Yeah,
Wow.
you can hit them a lot harder.
I need to move to North Carolina. I need to move to North Carolina. Oh, wait, we got some student loan questions on TikTok. Okay.
Go ahead.
Can you touch on strategic default of private student debt?
Oh, yeah, I can. Um, Presuming that it is a truly private debt, not a federally guaranteed student loan. And you need to be clear about that. And by the way, the way that you know if it's a federal loan, federally guaranteed loan, or a purely private loan, go to studentaid.gov. That's the US Department of Education's Office of Federal Student Aid. You can log in with the same credentials that you use to get into your FAFSA, or if you don't remember it or don't know it, don't sweat it. You can just press a button and you can register there. That will give you all of the information that the US Department of Education has on any student loan that touches them in any way.
Okay.
Status, balance,
I got to make
who
sure I
has
add that
them.
to the list.
Yeah, studentaid.gov. If it's not on studentaid.gov, presuming that you started school at some point after 1995, because that's when the online system came on board. So everything before 1995 was literally hand coded in, so it's imperfect. But presuming that you're after 1995, when it was just done automatically, if the loan isn't there, then it's private. So start from there. If it's a private student loan, you're in a totally different universe. A private student loan operates in the exact same way as a credit card debt does, in as much as they can't do anything to you unless they file a lawsuit. They can't do anything to you unless they get a judgment. They can't take your tax refund unless it's sitting in your bank account and they've filed a lawsuit and gotten a judgment. They can't take your social security unless the same thing happens. And then there are exemptions to that too. Up until the time that they get a judgment against you, everything is voluntary. They don't have to settle, but they can. They don't have to go by a certain number, but they can. You don't have to pay them, but you can. You don't have to do anything. They don't have to do anything, which means it's all a process of negotiation. In addition, private debts all have what's called a statute of limitations on them. It means
Mhm.
there's a limited amount of time that the creditor has to walk into the courthouse door to file a lawsuit against you. If they don't start the lawsuit within that period of time, they never can. So
So does that
they've got
only apply to private student loans? That doesn't apply to
yep,
federal, correct?
federal student loans can hunt you down until both feet hit the grave.
Real so like oh my god. So have you ever seen that happen? Like, because usually, like, people be like, "Oh, I went to default, it went to collections," and then they didn't hear anything. So is it they didn't hear anything because the company just decided not to pursue it, or is it like how does that work?
From federal or private? You're talking
Federal,
private?
federal.
Okay, from federal, again, federal's federal is only going to resort to the court system if there's no other way that they can get any money from you. There's no wages, so you're self-employed or you own your own business. You get no tax refunds. You are young enough that you're not going to get Social Security or other federal benefits for a long enough time. Um, and you owe a significant amount of money. In that case, the Department of Education will file a lawsuit against you in federal court, and then they'll go through that. They'll go that route. For private student loan, and the federal government doesn't love to do that. They don't, because if the loan balance is really high, then they're going to send it out to the Department of Justice, Attorney General's office, and those lawyers, honestly, they don't want to be bothered with this. Like they just don't. They have other things to worry about. They've got like white collar criminals to
Mhm.
pursue, and I'm not saying that they won't, but they would prefer not to. So they're going to go every other step necessary. If it's a smaller debt, they'll look for an outside attorney. My understanding is that they don't pay very well, so outside attorneys may be few and far between depending upon where you are. So for the federal government, a lawsuit is the last possible resort. For private student loans, they sue. They do. They sue. They sue all the time. But
Mm.
but they don't sue every time.
Yeah, but who really wants to play Russian roulette with with those loans? Like, do you really? Like, I'm not about to play chicken.
I
I can't
I
do it.
I respect that. I respect that. That being said, a lot of private student loan lenders will really negotiate hard, and they'll give you some really good discounts. Some before litigation, before they file a lawsuit, some through litigation. It depends upon the lender. It depends upon how the private student loan was handled, because private student loans they're bundled together and sold on the secondary market the same way that mortgages are. It depends upon not only the lender, but it depends upon how the rest of that pool of loans is performing for investors. It's kind of a delicate dance. But um, there's one private lender, who I will not name, that does not like to file lawsuits. They will, but they don't like to, because they don't want to take the chance that they lose the lawsuit in front of a judge who really likes consumers. Because if they lose the lawsuit, the next day they're on every Twitter feed,
Yep.
every TikTok video, every Instagram story, and nobody's going to pay them ever again.
Wow.
There's some significant room to negotiate private student loans. There really is.
And that's so funny because I think because of it just being a student loan and people forgetting to make that distinction between federal and private, that's just like that fear. Like, this is the government I'm going up against. Like, I could never. So it's really, I'm really glad that you actually made the distinction and kind of like eased people's spirit a little bit. Someone said, is there any reason you can get denied for rehabilitation?
Yes. You can only rehabilitate an individual federal student loan one time. So if you've been in default and then you've rehabilitated once, you can't rehabilitate again. So that's the first big bar. The second big bar is if the federal government has filed a lawsuit and gotten a judgment against you, you can't rehabilitate that loan, because then you're being handled by the legal system, not the administrative system. So those
Mm.
would typically be the bars to rehabilitation. Um, but I do want to touch on two things. First of all, how rehabilitation payments are determined, because by law, it's a reasonable and affordable rehabilitation amount. And I said it can go as low as $5, but I don't want people to think that it's a $5 rehabilitation. And I don't want people to think that, oh my God, it's going to be $1 million. Reasonable and affordable is, it's calculated, the standard way of calculating it is 15% of taxable income to the extent that that taxable income exceeds a baseline tied to the poverty level. So it's not, $1 billion if you're making 30 grand a year, just
Okay.
saying. And if that 15% isn't truly reasonable and affordable, like, oh my God, my mortgage is, exorbitant, it takes up all the money, and plus I'm paying these other loans and X, Y, and Z, then you can go through what's called a financial disclosure that allows you to account for your actual income and your actual expenses and use that as the calculation basis. And for a lot of people, that's going to result in a lower rehabilitation payment. It's a little bit more complex, but it's not crazy.
So for
So
those
that
living on like a fixed income, so the disability, the
Mhm.
Social Security and stuff like that, it'll be based off of that.
It's again, the standard way is you take your taxable income. So if, let's say you get Social Security,
Mhm.
but you're making below the, what is it, 25,
Yeah,
20 some odd $1,000, so it's not taxable, you've got no taxable income.
that's what I was wondering. Okay, okay.
Right. So
Wow.
you get the $5.
Damn, I should have went to college.
Never never too late. Never too late.
I'm going. I'm
Um
going. I'm telling you, I want to be like you when I grow up. I swear to God, like I want that.
well, thank you. So but that's your rehabilitation process. And again, it's taxable income. So it's not, even if you're a W-2 employee, and this is something that a lot of people miss. If you're a W-2 employee and let's say you make $60,000 a year, it's not based on $60,000 a year. It's 60,000 minus your pre-tax deductions. So your health insurance and your dental and if you're putting money into a 401k, that's all pre-tax money.
I'm learning so much. I'm running out of paper. Oh my God. Okay.
Um, and so it's taxable income minus 1.5 times the poverty level for a family of your size. Family means, Ohana means family. No, sorry.
Why I was literally thinking that when you said it.
But it's one of my two favorite movies. So family means you, your legal spouse, any children that are yours who rely on you for more than half of their financial needs. Doesn't matter where they live. Doesn't matter if you take them as a tax deduction. Doesn't matter if they live with your ex. Matters if you actually cover more than half of their financial needs. It doesn't matter if they're 30 years old and living at home and they've got their own job, but you're not paying them rent.
Mm.
Okay. It also includes anybody else who's not related to you, who lives under your roof and who you provide for more than half of their financial needs. I tell my clients, it's like everybody's got that one friend from high school that like never went anywhere. And
Yeah.
like they're like couch surfing and you can't get rid of them and they're eating you out of house and home. That failure to launch, if they're on your couch this month, they count. I mean, you may not want them as part of your family, but they're family for this
No,
purpose.
like for
Yeah.
real.
Yeah.
They help you in this case.
Exactly. At least one time they're helping. So that's how those numbers go. But again, one of the reasons why people don't like to get out of default is, what am I going to do with the other side of that? I still have the debt. I still have to deal with it. In that case, everybody needs to understand how the income-driven repayment plans operate.
Okay.
There are a ton of them. They all adjust your payments kind of in the same way that those rehab payments go. It's percentage of income, and different plans utilize income in a different way, whether it's you or your spouse, or you file jointly or separately. And there's a whole bunch of calculations that you want to go through, but it's taxable income minus that baseline that's tied to the poverty level. For federal student loans, though, if your income is below that baseline, you can have a $0 monthly payment, be in repayment, positive credit reporting because you're current and in repayment. So that's all good stuff. And all of the income-driven repayment plans lead to forgiveness after you've been in the plan, depending upon which one it is, after either 20 or 25 years.
Jesus. Whew. So when you do the rehabilitation, after the default is removed, can you like, let's say that some of the late payments are still they're reporting inaccurately originally, and I know you said that the late payments still report. Can you then go back and try to still get those fixed or whatever the case may be, or is it like you can't touch the past anymore?
If there's a reason, if there's a valid disputable reason, then
Like if you have the evidence to support what you're saying.
Sure. If there's a valid dispute, you can still do a valid dispute. Absolutely.
Okay. Okay.
Yeah.
Now, somebody said that their student loan has been turned over to Nelnet. Now, what are they supposed to do? They were notified that it was sent to them. What are their options now?
Okay. So Nelnet is a servicer.
Mm-hmm.
A servicer is just like your mortgage company. They don't actually own the mortgage,
Mm-hmm.
but they're hired by the owner to send you bills and process collection, process your payments and income-driven repayment and forbearances and deferments and all of that. So they're a private company. Nelnet's based in Nebraska, and they're one of a number of private companies. There's Nelnet. There's Advantage that took over all of the direct loans that Navient was holding.
Mm-hmm.
Navient still has the guaranteed student loans, but not the federally owned direct loans. There's Mohila, there's Great Lakes, there's a number of them. If the loan was transferred to Nelnet, that's who you start making your payments to, or that's who you deal with for your income-driven repayment or any forbearances or deferments. They're just the company that's taken over. And what people are finding now is a lot of their loans are moving from place to place. Navient loans all went to Advantage if they were direct. Fed Loan Servicing, which is the servicer that up until now has been overseeing everybody headed towards public service loan forgiveness, they're stepping out of their role as servicer, I think at the end of 22 or maybe the end of 23. End of 23, I think it is. So they're starting to shed some of their loans as well and have them reallocated. So loans are moving there, and there are a couple other companies that also bowed out at the end of 2021. So those loans are, it's like
They're going to be
three-card
moving
Monte. You
around a
don't know
lot.
where they're going to be. Yeah.
So if you had a loan that was with the Department of Education and then it was sold, are you will you contact the new servicer to begin the rehab?
Yeah, but no. The Department of Education doesn't sell loans. If they originated it or if they bought it after a default on a federally guaranteed loan, if they bought it, they keep it. They don't sell it. They never resell it. What happens is, at first, let's say you're with Nelnet. You're in good standing. You're in forbearance or deferment or what have you. You're in good standing. You come, something happens. You go into default. Nelnet takes the loan, gives it back to the Department of Education. And when I say give it back, it means Nelnet's been servicing it, sending bills and doing all that jazz. Nelnet then calls the Department of Education and says, well, this borrower's not paying. We're out of the picture. Give it to somebody else. We don't want to have to deal with this account anymore. It's like they fire
Mm.
the client with respect to that loan. Um, Department of Education then turns around and hires a debt collector to try to collect on that defaulted loan. They don't do it themselves. They have a debt collector, which for the most part at this point is the same company that owns Aidvantage.
Oh, okay.
It's just it's why Aidvantage got the deal, because the underlying company is a massive government servicer. They actually handle a lot of Social Security claims. They're
Mm.
they're the contractor behind that. They handle a lot of defaulted direct student loans, and so they were given Aidvantage as well. But the federal government will then give it to the debt collector. You'll have to deal with the debt collector. That's
Mm.
that's not really the same way that it goes for federally guaranteed loans. Like it, three-quarters of the problem with the system is that there's a million subsystems and there are just too many moving parts. Federally guaranteed student loans were originated by private lenders using federally guaranteed money. Under that program, the lender has to have a not-for-profit guarantee agency behind them. A guarantee agency is kind of like an insurance company. So that if the loan goes into default, the lender gives it to the guarantee agency, actually transfers ownership to the guarantee agency. Guarantee agency hires a debt collector. If the guarantee agency can't get money, then the federal government is like the backup insurance company. They're the backup guarantee company. So guarantee agency calls the Department of Education, says, hey, we're not getting paid off of this. Department of Education then buys the loan dollar for dollar. There's no discounts. So it's kind of a longer process there.
Wow, that is. When I say I'm learning so much, like I'm learning so much. Okay, so when we were talking about the difference between private and federal, I know you said federal, they're going to haunt you till your dying days. But private student loans, do they get sold to just regular debt collection companies?
Yep.
So then when they're sold to those debt collection companies, do those debt collection companies fall under FDCPA?
Yes, they do. So now if we're going to talk about FDCPA. So FDCPA covers any consumer debt, any household debt that is being handled by anybody who takes the debt after default. And that's important because not only does, say, your Amex card, if it goes into default, there's a debt collector that's going to be involved in it. That debt collector is going to be covered by the FDCPA. Private student loan, once that goes into default, debt collector, attorney who eventually files a lawsuit against you, if they do that, they're covered by the FDCPA. Federal student loans, the minute it goes into default, the debt collector that the Department of Education hires is covered by the FDCPA.
Wow. Okay. Okay. Now, speaking of the FDCPA, so something that I've seen as a credit repair specialist, and so I really want to make, I'm really glad you're on here because I want to make this distinction. The things that I've seen are not entirely legal. And this is what gets a lot of people off off of the hook for the debt, or they are allowed to sue. So the things that I see when I'm speaking from experience on these videos, you guys, it's not always legal. Just because it's not legal don't mean the companies will not do it. So when it comes to things like, for example, the big sticky point recently was in the video, and I know you and I talked about it, was when companies reset the statute of limitations on a debt based off of the information that a consumer provided them over the phone. That's not a valid reason to reset the statute of limitations, is it?
No, not in most states. And I'll preface this: I don't know across the board in every state what resets the statute of limitations. I can tell you in California, as well as in New York, talking to somebody, doesn't reset the statute of limitations. Even saying, yeah, I know I owe the debt doesn't reset the statute of limitations. There's
Wow.
got to be something in writing signed by the person who owns the debt.
Wow. That is so crazy because and this is another reason, you guys, why I say, like, yes, I talk about the federal loans all the time only because I'm talking to people all over the country, but it's very important for you to know your state laws. And what we mean by statute of limitations, this is how long a company has to sue you.
Mhm.
A lot of people get that confused with the reporting time for a debt, which is different. The reporting time is 7 years flat, no
Mhm.
matter what state you live in, and it's
Yep.
based off of either the date of first delinquency if the account is unpaid, or the date of last payment if it's a paid account.
Mhm.
But the statute of limitations is usually set by the date of last activity, correct?
Either date of last activity or date of default, depending
Just
upon
how
the
they put
state.
it on the credit report,
Yeah.
essentially.
Yeah.
So,
And
and the only thing that can reset your date of last activity in some states is a payment, correct?
in some states it's a payment. In some states it's a written agreement to extend. It depends state by state. And the statute of limitations varies state by state.
Yes.
California is 4 years.
My
That's
favorite is
it.
Texas, and I swear I can't wait to go to Texas because Texas has this thing. It's like this add-on to their law is just like once the statute of limitations expires in tech for a debt that you lived in Texas when you signed the contract, they can't reset the statute of limitations no matter what you do. That's it.
Look at
It's
that.
just dead. But Texas is one of the only states that has that protection.
Yeah.
Anybody else, even after the statute of limitations expires, if you make a payment or whatever it is that they say resets your date of last activity for your state, that will reset the statute of limitations, whether that debt is reporting to the credit bureaus or not.
Yep. That's zombie debt.
Hmm.
Mhm.
Oh my goodness. Like I'm telling, see, this is where I get fascinated. Like, this is why I'm just like so into this stuff, because just the distinctions between the different states. I've seen it in like repo law, like what one state allows, another state's like, oh, yeah, no, we're not having that. And then, like,
Yeah.
I know Ohio, their statute of limitations used to be like 15 years. I know they changed it to 6, and then they were in the talks to change it to 3. I know New
Yeah.
York just changed from 6 to 3.
Yep.
It's really important that you guys check your statute of limitations before you start disputing a debt, because you
Yep.
need to know what resets that statute of limitations. You need to know, because you don't, let's say you live in a state where an admission can reset your date of last activity. If they call you and you give them too much information because you want to be chatty patty on the phone, that can reset your statute of limitations. And now they have even longer to take you to court now, even if
Yep.
the debt is no longer on your credit report. Louisiana, I'm looking at you, because
Yep.
Louisiana statute of limitations is 15 years.
Mhm.
So it's
Yeah.
just so fascinating to me, like the differences in the states.
It is, and it gets super technical also because some states will apply their law. Some states will apply the law that's stated in the original contract that the consumer signs. Some will take the better of the two laws. California, for example, 4 years, unless the state that's put into the agreement, because every agreement will say this contract is to be interpreted by the laws of the state of fill in the blank. California will use that other state if their statute of limitations is less than 3 years, is less than 4 years rather. So they give you the benefit of which way you're going to go, if it's 4 years or the state of the agreement. And New York, like you just said, just went to 3 years for consumer debt only.
Mhm.
Private student loans are considered consumer debt. So let's say you live in New York, you're 3 years past due, you move to California, they file a lawsuit against you in California. Well, guess what?
They're gonna
Three
go by New
years
York
past
law.
due. Yeah, they're like, oh no, wait, it's within the 4 years. Nope, they go by the 3.
What?
And yep. And a lot of states also have what are called tolling provisions. Um, the clock stops for certain reasons. Um, and this is a big thing that military families
Mhm.
have to contend with. California is 4 years, but the clock is paused while you're outside of the state of California. So if
Ooh,
you're in San Diego, you get shipped off to Germany for 3 years. You come back and,
the clock starts.
forget about, forget about like if you're active duty or if you're a spouse or whatever. But if there's nothing else to pause that statute of limitations, just you not being there is going to pause that statute of limitations. If you file for bankruptcy during that period of time, your statute of limitations is going to be paused. There's a whole bunch of ways that can happen. So you want to be sure about that. I got to put on my headphones just because my
Yeah.
AirPods are breaking down. Hang on a sec.
And
Let's see if I.
everybody, if you got, listen, he has a lot of information. Like when I say I literally obsess over his content when I'm talking to you guys about consumer law and things like that. He has a lot of really good information about consumer debt, things like bankruptcy and student loans. When I say I literally live for your content, like, or when I'm referring to it, like on calls, or when I'm talking to people who really just have issues understanding like certain aspects of student loans and stuff like that, or why certain things happen, like I always point to you. Like, everybody, please follow him, please. Oh, I think you're muted because you unhooked your headphones.
Can you hear
Somebody
me?
yeah, I can hear you now. Somebody had a question. Where did it go?
Um,
Oh, I did have one more question because I actually got this question last week. I did a webinar for like college graduates and stuff like that who
mhm.
were beginning to build credit. And the one question I keep getting over and over is there a way for parents who sign for their kids' student loans, is there a way for them to kind of come back to the table and renegotiate payments?
Federal, no.
Ooh.
Or let me change that. Federal, if it's a parent plus loan,
Mhm.
which is the loan that the parent or the grandparent takes out for the dependent child, a parent plus loan, you can get into an income driven repayment plan that again is going to adjust those payments accordingly. Um, and by the way, those parent plus loans, if you qualify for forgiveness, whether it's public service loan forgiveness or disability discharge or any of that, that parent plus loan is still going to be covered by that forgiveness. So it doesn't matter if the student is, whatever, if you qualify for forgiveness because it's your name on that debt.
Oh.
Um, yeah. For private student loans, again, you got to go into default and then they'll come to the table. And again, there are so many great settlement options for a private debt. It's the process of negotiation. It's not an overnight thing, but I've gotten some really good settlements. I'm not going to say what it is because then people
I
are going
think that
to,
they can get
yeah,
exactly
be like,
that.
oh, he got, X dollars. No. But some really good settlements with some really long repayment periods and some really low all the way down to zero interest. Um, and private student loans, they don't always sue. They don't. So, I mean, this I can tell you. I had a client 3-4 months ago at this point, had $185,000 in private student loan debt, like from forever ago, and had been paying for a really long time. Went through a bump in the road, stopped making payments, moved, forgot about the debt, stopped paying 6.5 years ago,
Jesus.
won the student loan lottery, do,
Mm.
do a victory lap around the block.
Phew. Whew. I
Yeah.
should have went to college. No, I wanted to play Army, talking about something. Yeah, I'll go back later.
There's always
Mm.
time. There's always time.
Listen, like I told you earlier, like I start my classes in the fall, and I'm so excited because, like, literally, this is what I want to do. I want to do what you do. Like, I want to be able to go to court with people. I see the burden that it places on people. The student loan debt, the consumer debt,
Yeah.
and I want to be able to help with that. And right now, I can only speak technically. I can only tell you what the law tells me, but it's so cool that you actually have the experience to kind of go with that. Like, oh
Thank you.
man,
I
that's so cool.
I got to tell you, I think that and I say this to very few people. I really do. People, they say, "Oh, I want to be a lawyer. Oh, I want to go back to college. I want to do this." I got to tell you, if anybody can do it, you can do it. And I'll tell you why. Because um, we got connected through Rebecca, and I put something up, and she's like, "Oh, check out Marquia." And I went over, and the first thing I saw in your bio was, credit repair, and like my
Rolled
heart
your
stopped.
eyes
I
instantly.
was like, oh God, no,
Rolled your
no.
eyes instantly.
It is, everybody hates lawyers, right?
Mhm.
There is no your industry, and I'll call it say industry, and I don't want to lump you in
No, but it's the
all.
truth.
It is just, it's horrible. I mean, the stuff that I hear from people is ridiculous. And so I saw it on your bio, and I was like, oh, this is just going to be a train wreck. And then I went through all of your videos. I was like, wait a minute, she actually knows what she's doing.
Oh, that makes me feel so good. Oh God, oh God.
She's like actually skilled at this. She's good. I send people to you. I tell people to check your stuff out.
Oh, that means so much. Like I said, like you are literally goals. Like when I think about like and it's so funny. I was talking to my VA rep because I'm going to be using my retiree benefit to go back to school, and she was like, "So like, what made you want to be a lawyer?" And I was like, "This guy on TikTok." And she starts laughing, and like I sent her your page, and like we were talking, but like literally, like it's so funny. I tell people all the time, I fell into this. Like I experienced the same thing everybody who got terrible credit. I went to get an apartment. They told me, hell no. Like, and so I got into this kind of accidentally. And then the TikToks kind of happened accidentally. At the time I was living in Germany. Germany doesn't have credit scores. So the information that I have, I couldn't just go outside and start talking about it. So I got on the internet. And so like, the more I got into it, the more interested I got, the more I want to actually be the person to help make the change. And then I saw your content and I was just like, I didn't even know this was a real thing. Like this is they got a whole department for this. Like you should have seen me researching like what kind of degree do I gotta get? How many classes are they gonna make me take? How hard is the bar? Like I've been taking like little demo tests online and everything because this is literally like you're living my life. I mean, I can't be a white man, but every other aspect, you're literally living my life. Like I want to do this.
Well, come on in. I sincerely mean it. Look, there's as far as credit, I'll say credit repair to incorporate. There are only two people, and it's you and there's one other person on TikTok that actually know what they're talking about. And you both have very different approaches. And she comes at it much more from a mortgage standpoint, and she's good at what she does. But I got to tell you, the stuff that you put out, and how long have you been doing this? Don't even answer.
Honest. So
sure, go ahead. Because I'm thinking in terms of years. I'm not thinking.
So like, yes,
really?
Unofficially, like I would give people advice because like I said, I lived it. I had to fix my own credit. But like the law stuff and like really getting into like the behind the scenes, 18 months.
No.
18 months.
No.
18 months.
Wow.
And so like, and when I tell people that, they be like, really? And I'm like when I tell you, I'm literally like, I have like the FCRA in here highlighted 1,000 times. Like I'm reading actual like journals. You know how like they release like medical journals? Sure. I'm reading like statements from like bankers and like lawyers and reading case notes and stuff like that from people who are like suing all these different like I'm really into this. Like, wow. And I think that's what makes me so passionate about it because I actually enjoy it.
Yeah.
Like I literally love doing this.
Well, you're damn good at it. You really are.
Thank you.
And like I said, I don't say that there are people that I go into their lives and I can't.
I get exactly what you're feeling.
I can't. I'm like, you have followers? Like people are paying you money. Are you kidding? You're making stuff up.
Like, no,
really?
No.
You're just like, you're making stuff up here. This isn't real. Like, I don't know. But yeah, I'm so happy that you're here and here just in the world doing this. I can feel the amount of the amount of passion that you have for this and for doing what you're doing. And I just want you to like roll over every one of these other credit repair people on
Listen, I'm
TikTok as well as
coming.
anywhere
I'm
else.
coming. I'm
Well,
coming.
good. It can't come a moment too soon. People need the help. They really do.
But I just want to thank you so much. Like, because I'm not even gonna lie to you, I was super nervous to even ask you to do this. I was like, this man got much better stuff to do than to get on TikTok with me. But I just want to, because like I said, I can speak from the book, but
Mhm.
having you speak from experience, I think is the most important thing, because I can tell you how it might happen. You're in the courtroom. You've seen what the judges are saying, how they feel. You speak with other lawyers, so it's easy for you to be like, that should happen. But this is what really happens.
Yeah.
My last question, and then I'm gonna cut you loose because we've been on here for
Sure.
a while.
Sure, sure.
When it comes to suing company debt collectors or creditors who
Mhm.
violate the FCRA and the FDCPA, can you
Mhm.
talk a little bit about that process?
Tell me where you want me to start.
So how do you even begin? Like, if you noted, damn, hey, she said that's against the law. Okay, now what do I do after I contact the lawyer?
Okay. So let's start with the FDCPA because
Mhm.
in some respects that's easier. If the attorney reviews either the letter or if there are call notes, or if you live in a one-party state where you can record and you have a copy of the recording, or even a two-party state where you've disclosed that you've recorded and you have a copy of that recording. Once the attorney takes a look at that and says, okay, we've got a case here, they they don't get in touch with the other side. Like that's not a thing that we do. They did a bad thing. That's it. File a summons and complaint in court. That summons and complaint lays out the basis of the claim. It gets served on the debt collector. Debt collector calls their lawyer, freaking out, say, I'm getting sued again.
Literally.
Again, this is not anybody's first rodeo on that side. Their attorney files an answer to the complaint, and at that point, legally, it's called issue is joined. That means now we got a fight on our hands. Um, at that point, the case goes through what's called the discovery phase of litigation, which is everything from the moment that an answer is filed until either settlement or trial, whichever comes first. So you'll exchange documents, you'll exchange information. If there are going to be depositions, which are just sworn statements and opportunities for questions and answers to be handled by either side, that's when that all gets taken care of. It's kind of like if anybody's ever shown you how to play a card game,
Mhm.
it's the first hand you always play open,
Mhm.
right? That's when everybody shows their cards. What do you have? What do I have? What's the level of proof? So that both sides can A, avoid surprises, and B, they can assess their risk, because that's ultimately what litigation is all about. It's all about assessing risk. Are we going to lose? How much are we going to lose by? Um, what's our risk of loss? And does that risk of loss mean that we want to sit down and talk settlement? Most lawsuits never see trial.
Mm.
Most lawsuits are settled. It's just the way that it is.
So if,
Nobody. Go
if
ahead.
you win,
Mhm.
then what? Do you no longer just you? So let's say somebody's suing you and I win. Do I not owe that anymore? Like, how does that work?
If Well, wait a minute. You mean, what if somebody's suing
So let's
you
say this
for, say,
company
the
is saying
debt?
that, yeah. So let's say they're countersuing. So like, let's say I sued a company because they violated the FDCPA, but they're like, well, wait, you owe us money anyway. Like, how?
That's not a countersuit. That's a totally different ball of wax.
Oh,
Right.
okay.
That's like I'm I'm playing baseball. I got a set of rules.
Hmm.
If I break the rules, it doesn't matter if I've won or lost. That's a totally different question.
Okay.
Right.
So even if you like, let's say even if they sue you, right, and you win, if they and they win, if they violate the FDCPA, that's a whole separate case.
Yep.
Wow. Okay.
hmm Now, if they're suing me for the debt,
Mm-hmm.
let's say I owe $5,000 and they're
Mm-hmm.
going to sue me for the debt, I can countersue against them for violating the FDCPA
Ah,
because
okay.
that changes the economics of the situation, and also because um, from a consumer standpoint, it's a lot easier for
Mm.
the consumer
And
because
so
then
is that something I would just include in my grounds of defense, or is it
it
other paperwork?
it would be a countersuit as opposed to a defense.
Okay.
Yeah.
Okay.
Um, it's countersuing is yeah, but how
Mm.
about this? Not which is a
Okay.
defense. Right.
Okay.
There you go.
Okay. You know what? So I actually got it when you said it like that. I actually got it when you said it like that. When I tell
That's
you, I'm literally gonna take that clip that's gonna be my next IG reel, like because that literally summed it up for me. This is so cool, especially because I've been vlogging my experience. I'm being sued by a card I've never had before. So for
Ooh.
me, it's something special because I feel like it's identity theft and all this other stuff. But like when the judge was explaining the stuff to me, like the bills of something, and then I had to do the grounds of defense, and I was like, "Ma'am, are you saying this in English? Like, can you speak slower?" And it was very intimidating
Yeah.
being in court by myself.
Oh,
And then
yeah.
they got like three lawyers sitting at the table with stacks of paperwork, and I felt so lost and terrified.
Oh, it's horrible. It
Like
it it is. It's off-putting. It's foreign. They're using different language. The lawyers all seem to know each other. The judges
yeah.
know the lawyers. Oh, I'm going to call your case first because I know you and you've been around. And you're like, oh crap. I it, you it's it's real. It's a real thing, no question. And you know, look, in case you hadn't noticed, I'm a white guy. If I go into court, I'm going to get a little bit different consideration
Yeah.
than somebody who's not a white guy. It
That's
just
just how it
is.
is. Yeah.
The system is set up to intimidate and to make people fail.
Mm.
And I also I've got kind of a side theory that has yet to be proven, but um I have a side theory that debt collection is not designed to get people to pay. Debt collection is designed to condition people to ignore letters and to ignore phone calls so that when they do get sued, they don't
Mm.
file a response to the claim, and then the creditor gets to get the default judgment against them.
And I say that all the time.
Do
Like
you?
when I went to court, so I had my first little appearance, right?
Mhm.
And I'm in there with my little briefcase and I'm ready.
Mhm.
I'm thinking we about to go at it. I had my little FDCPA booklet highlighted and tabbed. Like I was ready.
Mhm.
And first of all, I was late. And anybody who knows me know I'm always late. So I'm late. I'm walking in. And so by that point, they probably had already called like, a couple cases. And they called
Mhm.
like 20 more people before they even got to me. And
Yep.
all 20 of those cases, because nobody stood up, they were like, oh, well, we're going to go ahead. How much is it for? All right, yeah, we're going to go ahead and give it to you. Next one, next case,
Yep.
next case. And I'm just like, yeah, like, and when I'm talking to people, now that I repair credit, or I'm meeting with people who are debating whether or not they're going to pay this stuff or show up in court and stuff like that, and I'm like hearing them, and the first thing they say is, "Well, I got a letter in the mail saying that they want to take me to court, so I'm gonna just go ahead and pay it."
Mm.
It don't even have to be a valid debt. I'll be like, "So where did this debt come from?" I have no idea, and you're just
Mhm.
gonna pay it because
Yep.
that fear. They've already put the fear in people that you're not gonna win this.
Yep.
You have no like you're not what girl yeah no we're going to take the money, we're
Yep.
going to take the money, and so people pay before they even get that far. But just because these companies have enough money to hire a lawyer doesn't necessarily mean they have a case.
Bingo.
And
Bingo.
this is why I tell people all the time, when you guys are on TikTok and you're listening, even my tips, trust but verify. all
Oh,
these
I
people,
love you.
all these people saying you don't go to pay. Oh, my favorite,
That's
according to the FCRA Act, you don't have to pay these items back. Like, and everybody says the same thing, but nobody explains to you what happens when you don't. And then they take you to court. So then when it happens to you, you're panicking.
Yep.
And you don't know the law because you never did the research. You have no idea what the state says as far as, how long this debt has even been sitting, whether or not you still owe, things like that. And so you just pay it. You just give them the money and they
Yep.
get rich like that. They literally
Absolutely.
get rich like that.
Yeah, absolutely.
Ah.
It's kind of like when my son was really young and he was starting to learn how to cross the street by himself, and we're living in Brooklyn at the time, where it's kind of a full contact sport. But I'm born and raised in a Brooklyn before they were on T-shirts, so different
Mm,
universe. But he we were teaching him how to cross the street, and the light was green for him, red for traffic, and there would be a car coming, and he'd take a step out onto the street to start to cross. I'd say, no, you can't cross yet. It's like, why? I have the green light, they have the red. I'm like, you don't want that to be your last words on a tombstone. It's like, I had the right of way. It doesn't matter.
mhm.
Just because you can't doesn't mean that you won't. Um, so yeah, 100%. You can't just ignore this stuff. Um, and to a large extent, if you're being sued and it's a debt collector, it's not a debt collector as in, well, I owed Amex and now they hired a
Mhm,
ABC collection agency and now I'm being sued by Amex and they have a lawyer. It's
mhm.
I'm being sued by fill in the blank third party that bought the debt, that
Mhm.
owns legal title to the debt. Um,
What's the proper term for that? Because I know in my industry, we use debt collector very interchangeably, and
yeah,
there are distinctions. So, what are the proper terms for that?
the proper term, the technical term is debt buyer
Mm.
because they've actually purchased all the right and ownership in the actual debt.
And how do you know the
And
difference?
um, you kind of don't until they file a lawsuit against you,
Mhm.
because then it won't be American Express plaintiff. It would be,
The company.
ABC company plaintiff. And
Mm.
it's a multi-billion dollar industry, financed largely by the private equity companies that these originating banks have formed and developed. Um, and that process of debt buying, some people would be like, "Oh no, they sold the debt; they can't do that. They could do whatever the hell they want. That's it's legal to sell debt. It's okay."
Mhm.
Um, the process of how debt is sold, though, if you really want to fall down a rabbit hole, I
Don't tell
will.
me that. Don't tell me that.
Oh,
Ugh.
oh man, this is a deep one, and it's going to feel like getting on the wrong side of YouTube after a couple hours at 3 o'clock in the morning. Um, I,
You
I,
be you be watching me? How do you know?
we've all been there. It's like, oh my God, it is a conspiracy. No, but the way that consumer debt is sold is usually through a process. Um, the agreement is actually entered into years before anything happens. They're called forward flow or future flow agreements. And the one big one that was kind of the big one for many years was Citibank had an agreement with a company called Sherman Acquisitions.
I've
Um,
seen them.
okay, so there you go, and Sherman has a whole bunch of subsidiaries,
Mhm.
but it was Citibank agrees to sell to Sherman every debt that is charged off that goes through charge off,
Right.
for X amount of cents on the dollar, and that's subject to whatever market rates are at that point. And what would happen is, and what does happen is, you'll come into your office one day, turn on the computer, and kind of like when you turn on when you call up Outlook or whatever your email program is, and all your email comes in, it's kind of the same thing. You open up your computer in the morning, and there's 50,000 new files, and your bank account is X dollars lighter because the payment's gone through automatically, the account has been sent to you automatically, and those accounts may not have even been in existence when the agreement was entered into. So like they're negotiated years and years in advance. And a lot of the times, what's transmitted to the debt buyer is name, address, phone number, social security number, originating creditor, date the account was opened, date of last charge, date of charge off, balance due. You want anything else? You want a copy of the agreement? You want a copy of the statements? You're going to have to pay, $50, $100 more to the debt to the original owner of the debt, which isn't a whole lot of money if you're buying one account. But if you're buying 50,000 accounts at once, you're not going to spend $50 a pop.
That explains why a lot of times they don't even sue for like low dollar debts. It's not worth it because they have to kick out too much money to even get the proper documentation to do so in the first place. Everything is like clicking and falling into place for me now. This is crazy.
It is absolutely crazy. If you get sued for a consumer debt of any sort, if you file an answer, if you respond within the time specified by law, and you don't sit around and say, "Oh no, they didn't serve me the right way," because you're thinking it's all law and order, and that's not the way that it goes in the real world. But you're like, "Oh no, the guy in the trench coat didn't show up and say, are you John Smith? Here's your paper. You've been served." Dun dun dun. Yeah, that's not how it works in the real world.
Mm-hmm.
But so long as you're not gonna take that position, and instead you look at it and you're like, "All right, great, I got served. Now I gotta file a response. I got X date, X time. This is what I do. This is how I do it." So long as you do that, your chances of winning, particularly when we're talking like credit cards, personal loans, like normal stuff, like you're up to $10,000 debt, your chance of winning just exploded through the roof.
Really? All because you answered. They kind of bank on you guys not answering and not showing up. That's how they make their money. Man, everything is all coming together.
Yep.
Yeah, because when I stood up, they were shook. They were about to skip to the next case. And it's so funny. So I'm 5'10". So like, when I stood up, I stood up. So then like the bailiff kind of looked and then like did a double take. And then like they were about to move on to the next one. And he was like, wait. And then like pointed. And it was like, oh, yeah, okay, come on up. Like, man, that's so crazy.
Yep. So crazy. And when you go to court, you never, ever want to make an excuse. Like a defense isn't, "I ran out of money, Your Honor. I had a hard time. I couldn't afford the payment." Because what you've just done is you've kind of walked in the side door of admitting that you owed the debt, right? It's like, "I couldn't afford it." Well, if you didn't know the debt, who cares if you could afford it? You didn't know the debt.
Right. And for those of you who are watching who saw the video I did where I talked about the script to get debt collectors to stop calling you, this is why. I don't know if you guys were in here earlier, but I said some states will allow an admission, right, to reset the statute of limitations. And as a consumer, you don't know what not to say. When the average consumer doesn't know what an FCRA or FDCPA is. And so y'all get on these phones and tell these people way too much of your information. And that can reset the statute of limitations on a debt. Now you're behind the 8 ball even more. And so that is why I put that video out. It wasn't for people who just don't want to deal with it whatsoever. It was more so for the people who are like, "Look, just stop calling me. I want everything in writing." If you are working with a credit repair specialist, you should not be talking to these people over the phone. Like, you should trust your specialist to be like, "Nah, whatever you got to say, pimp, put that in writing." I'm not listening. Put it in writing. And then, we'll talk, I'll have my people call your people. Like that's how you have to play it. And it's not shady or it's not like, "Oh, it's kind of weird." It's to protect you at the end of the day. Everybody think that when they talk to these people over the phone, or even when they call the bureaus and they're talking to customer service reps, these people are running a business and these people work for that business. They do not work for you. I tell people all the time who work in corporate, HR is not there for you. They're still employees of that company. And so even though it sounds like they're trying to help and they're trying to work something out with you, at the end of the day, this is their job. And 100%. So you guys have to understand that these things are to protect you. Now, what you do with this stuff, that's your business. My job is just to make sure you guys have the resources and the tools available to you so you can protect yourself. Just because you can't afford a lawyer or whatever the case may be doesn't mean you're not entitled to the same respect and protections. Absolutely. And that's what the content is about.
Absolutely. 100%. Don't make excuses if you go into court. Dress like you want to impress somebody, but you're not looking to walk in there like a superstar. Like leave
Yes,
leave
please.
leave the Chanel at home, but you know, this isn't the day for your t-shirt from Old Navy either that
Mhm.
you were painting the house in during the weekend. Um, it is amazing just how much that little bit of reading the room does for somebody. Like you don't have to wear a full suit, but you're pretend like you're going over to a significant other's house and meeting their family for the first time. Like
I like that. I like
that
that.
yeah, that's the way to do it. Um, Judges are grumpy. Judges are a lot of them are completely out of touch. Um, but beyond that, they're all human. And if you get somebody on the wrong day or who's just got some sort of an attitude about something, it's going to change the outcome. It just is. Um, I I wear earrings. I take my earrings out before I go to court. Like I just do. It's just something. Um, I've I I had a client I was representing, and we're standing in court, and my clients, they're like they're in the right frame of mind. They're presenting properly. They have the same exact case as somebody who is completely presenting in a different way. My client had a better outcome. I'd love to say that it was me, but we weren't really doing anything that would require my involvement. It was just the way that they were presenting. And judges are 100% human. I'll tell you one really quick story. I had two cases, and there's private student loan litigation and consumer litigation in general against when debt collectors are suing. If you've done one against a particular law firm, you've done 1,000 of them because it's all just they they hit Control P and they print it out and that's it. It's the same thing, different names. Uh, so I'm I'm defending two people against the same private student loan lender. Okay, it's the same school. They're approximately the same age. They're approximately the same person for all intents and purposes. Like 99% of them is completely different. They're both getting sued in the same county in
Mm.
in LA Superior Court. One's case is in Chatsworth, which is in one part of LA. Another one is in Norwalk, which is in another part of LA. They've got different judges. The private student loan lender brings what's called a motion for summary judgment, which is basically their shortcut for, look, judge, we don't need to go to trial. Here's all the facts. There's nothing in dispute. Just let us win. Let's all go home. It's a shortcut process. And they don't use it that often, but they did in these two cases. One client went up, and the judge he was like the former president of one of the yacht clubs, like
Yeah.
just like that guy. Um, my client lost. I could have told my client that they were going to lose as soon as I walked into the courtroom and I saw who the judge was. It's like, that guy. Nope, you're going to lose. Doesn't matter. Client lost. A week later, the other client, we walk into court and their judge is not the former head of a yacht club. They had worked in legal aid, on consumer side work, down to earth, normal human being person. As soon as we walked in, I turned to my client. I said, "We're good." I said maybe 3 words.
Mm.
We won, walked out, same case, same
Mm.
argument. I reused my same response with the permission of both clients. Um, I used the same response because it was the same motion, basically.
Wow.
Call and answer over and over again. One judge we lose, one judge we win. The only difference is who's the human being who's listening to it and what's their attitude. Same thing every single lawsuit.
Mm. Man, we have to do this more often because, like,
Yeah.
I've already kept you for like 2 hours, so I am gonna go ahead and let you cut out.
Yeah.
But like, oh my god, like I feel like I have like a bajillion questions. So we definitely have to do this again. This was amazing.
Thank
Everybody,
you.
please make sure you're following Jay. Somebody
Thank
asked for your
you.
Instagram because I can't remember if you said it earlier. Is it still Money Wise Lawyer?
It's MoneyWise Law.
Money Wise Law on
Yeah.
Instagram, guys. But
Yeah.
thank you so much. Like I
Thank
said,
you.
you are really the standard for, for I can speak for myself for what I'm trying to do. Not even necessarily as a credit repair specialist, but as a consumer advocate. Like my biggest thing is I want to make sure I'm giving the right information to the, for the people, so that they're not as helpless as I was, when I was going through my stuff. And then, eventually my goal is to be a consumer lawyer so that I can have that experience to speak from too, and not just, well, the book says and the law says. So, man, like, thank you so much for doing this. This definitely meant a whole lot to me. And
Thank
I'm
you.
still going to be devouring your content. So,
And I will be devouring yours. And I don't know if you know this, but I'm always in your other lives, like when you do either your solo or your group lives.
really?
I think I've been in. I I don't know how often you do them, but I feel like they're almost every night or every other night.
Yes. Yeah, they are.
Well, and the other creators that you're in with, I'm like the first time, and I don't know very many creators' names, like even their usernames, just completely
Over the,
completely
yeah.
fly by me because I'm looking at the person, not the bottom of it. And the first time I went in, I'm like, oh, wait a minute, I know that person, I know that person. Hey, I like all these creators. This is great. So I said all of them. It's great. So yes. So thank you for that. Thank you for everything you do, and everything that you do content wise is spot on. And just keep doing what you're doing.
Man, that means so
You're
much.
fantastic. Thank you.
Thank you so much. And thank you everybody for watching. If you
Thank
weren't
you.
here for the beginning, it is saved on YouTube. Literally, as soon as we get off, you guys can go watch it from the beginning. And I'm also going to send you a copy for you to post as well. But
Cool.
I'm going to go ahead and end the live. Thank you everybody for watching. I'll talk to you
Thanks,
guys soon.
everyone. Bye.